Good day everyone, welcome back to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Simon from Maserumule, and in today's episode we will unpack what if an employee engages in unlawful money lending activities at work? Is dismissal a fair sanction? This was the question the Labour Court had to determine in the matter of Kaweng versus South African National Biodiversity Institute and others. As we always do, let us start by setting out the background and facts of the matter. The employer, the South African National Biodiversity Institute, received a whistleblower report alleging that a loan shark was operating at its premises. The employer investigated the claim and established that a certain employee had been loaning money to its other employees at exorbitant interest rates of 50%. Following this, the employer leveled disciplinary charges against the implicated employee, who was ultimately dismissed. During the course of the disciplinary hearing, Mr. Kaweng was incriminated. The employer therefore leveled the following allegation against Mr. Kaweng. It is alleged that on or about the year 2017, you participated in the unlawful money lending scheme within his premises for your own benefit during official working hours. Mr. Kaweng was found guilty and was dismissed. Mr. Kaweng challenged the fairness of his dismissal before the CCMA, contending that he had been involved in a stokvel and not an unlawful money lending scheme. Furthermore, he denied that his conduct was detrimental to the employer's operations. In response to Mr. Kaweng's contention that he was involved in a stokvel and not an unlawful money lending scheme, the Commissioner noted that under cross-examination, Mr. Kaweng conceded that some people had borrowed money from the stokvel. The Commissioner noted that in instances where a stokvel is used as a money lending scheme, interest is charged on the loan. The Commissioner found that the Department of Trade and Industry published a notice on the 11th of May 2016 determining that the threshold for registering as a credit provider with the National Credit Regulator is 0 for all applicable credit providers involved in lending money, and only a loan which does not include interest or a fee for late or deferred payment will be exempt, as it would not fall under the definition of a credit agreement in the National Credit Act, and registration as a credit provider will not be required. On this basis, the Commissioner found that Mr. Kaweng's version that he participated in a stokvel and not a money lending scheme was highly improbable and not plausible. Based on the above, the Commissioner concluded that Mr. Kaweng was involved in an illegal money lending scheme. In response to Mr. Kaweng's denial that his conduct was detrimental to the employer's operations, the Commissioner held that Mr. Kaweng was one of the founding members of the scheme, and it was undisputed that some employees who did not honor their repayments were threatened by certain members of the scheme, and accordingly accepted that although there was no evidence that Mr. Kaweng had personally threatened the borrowers, the members of the illegal money lending scheme had either collectively or individually intimidated the borrowers who did not honor their repayments. Accordingly, the employer's contention that money lending had detrimental effects on its operations was supported. Mr. Kaweng unsuccessfully challenged his dismissal at the CCMA, and accordingly he approached the Labour Court on review. In the Labour Court, Mr. Kaweng argued that the National Credit Act provides that a transaction between a stokvel and a member of the stokvel in accordance with the rules of that stokvel does not constitute a credit agreement, with the result that the National Credit Act does not apply, and therefore the stokvel was not operating illegally, and that once he became aware that money was being lent out and interest was being charged, he resigned from the scheme. The Labour Court found that based on Mr. Kaweng's evidence, the financial scheme changed from a stokvel into a formal money lending scheme, in terms of which employees and others were granted loans and charged interest. The Labour Court also found that on Mr. Kaweng's own version, the change required registration which was not undertaken. Despite this, Mr. Kaweng continued to participate in the scheme and presumably shared in the profits of the scheme. On this basis, the Labour Court concluded that Section 82C of the National Credit Act, which formed the basis of Mr. Kaweng's defence, found no application. The Labour Court held that even if the money lending scheme was somehow not in breach of the National Credit Act, the Commissioner's decision of upholding Mr. Kaweng's dismissal would nevertheless have been reasonable. This was because Mr. Kaweng had participated in the money lending scheme at work, with fellow employees having been charged exorbitant interest rates, and there was evidence of the scheme having caused disruptions in the workplace. South African society has long been characterized by stokvels, which are crucial as a tool for social protection. The importance of this case is to highlight the following. When the stokvel lends money to members and/or third parties and charges interest on those loans, they run the risk of turning into illegal money lending schemes. Stokvels that function as money lending schemes may cause problems at work if disagreements emerge among stokvel members or between these members and other parties to whom the stokvel has extended loans. In this regard, when employees are unable to repay their debts, they could steer clear of the money lenders at work. Another risk is that employees may be secretly profiting from the interest they pay, which would be against the employer's will, especially while they are at work. Employees may be spending more time and focus on the money lending operation at work rather than on their own responsibilities. Therefore, we believe that employers may be able to defend the creation of regulations governing the use of stokvels in the workplace, at least under certain conditions. Employers may also establish policies that forbid lending in any way, whether through stokvels or on an individual basis. And in conclusion, it is our view that employees should be made aware of the fact that stokvels which lend money and charge interest thereon may be in contravention of the National Credit Act. Colleagues, that brings us to an end of this week's discussion. We hope you have found it informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.